Sir, the issues are straightforward in that my client totally denies the allegation and wishes all prosecution witnesses to attend at trial.
Has the case management form been completed?
No, sir. As you'll be aware, there are some 24 cases in this list, and I'm afraid I hadn't had the opportunity to speak to my friend about this matter before it was called on. We are in agreement that all witnesses at this stage will be required and that the trial will need a full day's hearing at least. Might I respectfully suggest that the form be completed by myself and my friend at the end of the court's business and submitted to your legal advisor as soon as possible?
I support my friend's submission, and as I am required in Court 7 immediately to start a trial, I would be grateful if the form could be completed on a later date.
It's suggested that the trial of this case will take in excess of a day. Court time is precious and isn't to be set aside without a proper exploration of the issues. The court is simply not prepared to allow the parties to avoid their obligations under the criminal procedure rules by not completing the case management form either before or during the first hearing, and I'm going to set the matter back so that that can be done.
So, returning to the case of Jason Newton, the parties have now completed the case management form and they agree that this case will take a day and a half. I have consulted the listing department and a date has been put aside, so perhaps you would bill a defendant to that date.
Thank you, Miss Badell. Before I do that, could I please see the case management form? I'd like to discuss this with the advocates. I see from the case summary, Mr. Barker, that the Crown allege that the defendant went into Spendthrift supermarket, was then seen to be behaving in an unruly manner, throwing items about. He was then asked to leave, and it was whilst he was being escorted off the premises by Mr. Singh, a security guard at the supermarket, that it's alleged the assault took place. Is that a fair summary of the case?
Yes, sir.
Miss Mirren, you've stated in paragraph 8.4 of the form that the issue in the case is, and I quote, purely factual. Perhaps you could help me by explaining exactly what you mean by that.
That it is merely a question of fact, sir.
Well, that doesn't really help the court, does it? What issues of fact are in dispute?
It was self-defence.
Perhaps you could be a little more precise. How exactly do you say your client used lawful force to defend himself?
My client maintains that he was in the supermarket lawfully. He had behaved himself quite properly and vehemently denies any antisocial behaviour alleged. There were absolutely no grounds to require him to leave the supermarket, let alone use force to do so. The security guard just grabbed him without explanation and began propelling him forcefully and aggressively towards the exit. Mr. Newton had no idea who this person was or what was happening and simply pushed him to get him off. The security guard fell, and that must be how he acquired any injuries alleged.
And what did the prosecution say happened at this point?
As you rightly suggested, sir, the defendant was asked to leave the store by the security guard on the instruction of the store manager, who'd been informed of his behaviour by a third member of staff. That member of staff, a Mr. Hawkins, had also asked the defendant to leave. He was further asked to leave by the security guard, a Mr. Singh, who was in uniform. He took the defendant by the arm, and the defendant punched him with force so that he stumbled backwards and fell to the floor.
So those are the facts that will be in dispute at the hearing?
Yes, sir.
I see from the form that there are 6 prosecution witnesses listed, and all are apparently required to give live evidence at trial. I need to satisfy myself that the attendance of each witness is absolutely necessary. What can you tell me about that, Miss Mirren?
Well, I haven't had an opportunity to take full instructions yet, sir, and at this stage I am not in a position to agree any of the prosecution evidence.
Miss Mirren, I'm sure I don't need to have to remind you of your obligations under the criminal procedure rules, particularly parts 1 and 3, which apply equally to the defence and which I'm well aware you are aware of. The early identification of the real issues in dispute and the needs of witnesses are a crucial part of case management. I can see and understand why it's necessary for Mr. Singh to attend, but what of the other witnesses? For example, Miss Summers, the store manageress. She didn't see any of the initial behaviour of the defendant, and although she directed Mr. Singh to remove the defendant from the premises, she didn't see anything of the alleged assault upon him. On what issues would you want to cross-examine her?
Well, sir, although she didn't witness it, she says that Mr. Hawkins told her that Mr. Newton had been unruly prior to the alleged assault, and that's hearsay.
Yes, I understand that, but that doesn't need to worry us because Mr. Hawkins is to give evidence on this point, and that part of Miss Summers' statement that is hearsay can be omitted by agreement with the Crown, and the balance of her undisputed statement could be placed on a Section 10 admission, couldn't it, Mr. Barker?
Of course, sir.
On that basis, sir, we do not need Miss Summers to attend at trial.
Mr. Bailey, who is he?
I believe, sir, is that maybe the member of staff who located the CCTV of the incident?
Obviously, I haven't seen the video yet, so I've asked for Mr. Bailey to attend.
Did the Crown intend to rely upon this videotape at the trial?
Sir, I've just found a memo from the officer in the case which confirms there's nothing evidential value on the tape, and I don't intend to rely on it.
But I haven't seen this tape, and I cannot simply agree that it shows nothing of relevance. I insist that Mr. Bailey remains on the list of witnesses warned to attend and that the court orders disclosure of the tape.
The Crown have indicated that they do not rely on the tape. However, if it does show something that might reasonably be considered as capable of undermining the prosecution case or assisting the defendant, then it must be placed on an unused material schedule. Then the defence can look at it. Alternatively, Mr. Bailey can be tendered to the defence, and within a time frame of your choosing you can indicate whether or not you wish to call him and or play the tape at the trial. There is no authority, Miss Mirren, for the court to make an order of disclosure at this stage without a properly constituted defence statement being served, and if that doesn't result in disclosure, an application under Section 8 of the Criminal Procedure and Investigations Act of 1996. Now, getting back to the form, the next witness is Dr. Bodkin. What part does he play in this?
I don't know, sir. He doesn't seem to be on my witness list.
Perhaps I may assist, sir. Dr. Bodkin is the forced medical examiner who examined my client whilst he was in custody.
How is the doctor's evidence relevant to the factual issues in dispute?
My client sustained injury in the ensuing fight, and I want that evidence to be before the court.
Mr. Barker, do the Crown rely on this witness?
No, sir.
There's no reason why this evidence can't be dealt with by way of a Section 10 admission as to the extent of the defendant's injuries and their nature. If, for any reason, the injuries become relevant and an issue in dispute, then Dr. Bodkin can be tendered to the defence, who could be called to give evidence at trial.
Sir, we've agreed that those injuries can be made subject to a Section 10 admission.
Yes, very well. I note there are 2 police officers apparently required to give live evidence. The first is PC Wade. Why is she needed?
She is the arresting officer, sir.
Yes, I realise that, but why is she needed at the trial?
Again, sir, as I've already pointed out, we have not had sufficient time in which to take full instructions, and I've asked her to attend in case matters arise upon which she can assist.
Her notebook says she arrived in the store 45 minutes after this incident occurred. She went into an office. The reason for her attendance was advised to her. She then arrested the defendant, who made no reply after caution, and she then took him to custody, where he was later detained. How is that evidence contentious?
It isn't, but we might have something to ask her about the case.
Yes, but equally you might not. It seems to me the best way to deal with this witness is to accept her statement, Section 9, and then if any matters arise, then they could be added to the Section 10. I'm aware that a recent survey at a local court disclosed that some 60% of police officers called to give evidence remained unsworn at the end of the day. That's a situation that simply cannot be allowed to continue.
No, sir. Very well, sir, I will accept her evidence, Section 9.
And finally, PC Holmes. What part does he play in this?
He is the investigating officer and the interviewing officer.
Again, Miss Mirren, that's self-evident. Why does he need to attend the trial?
Well, I haven't had a chance to listen to the tape yet, sir, so I can't say whether or not the record of interview is agreed.
But the MG5 form on page 3 contains a summary of your client's interview, Miss Mirren.
Yes, but I haven't listened to the tape yet, sir.
Miss Mirren, according to what we've already been discussing, your client says that he acted in self-defence, and that is exactly what the summary of the tape-recorded interview discloses. I can see no reason why that shouldn't simply be added to a Section 10 admission. Having not listened to the tape, however, I'm prepared to allow 14 days for that Section 10 to be agreed. That way you have some time to listen to the tape and you can add anything to it that's relevant onto that Section 10.
Thank you, sir. I accept that that is a sensible way of dealing with the matter.
Finally, as far as witnesses are concerned, I know you wish to call one witness for the defence in addition to the defendant. Who's that witness, Miss Mirren?
A friend of the defendant who was present and witnessed what happened.
Has a proof of evidence been taken from this witness yet?
No, sir.
Well, then I direct that you notify the court within 14 days that you've taken a proof of evidence from the witness. You must also, of course, comply with the prescribed time limits for giving the details of that witness to the Crown.
Yes, sir.
Mr. Barker, there'll also be a direction that the prosecution will warn their witnesses within 7 days, and within 21 days there will be initial disclosure served. There's no need for the Crown to prepare a record of the tape-recorded interview because the defence have agreed that that can be admitted Section 10. Miss Mirren, is there anything else you wish to ask of the prosecution at this stage?
We'd like to know of any disciplinary record kept by Mr. Singh's employers.
Well, again, Miss Mirren, we've already discussed this. The court simply isn't in a position to order disclosure without the proper procedures being undertaken. And I repeat, that would involve service of a properly constituted defence statement, and if the items are not disclosed, then an application would have to be made. Are there any other steps that the defence need to prepare for trial?
I don't quite follow you, sir.
Well, the court is under a duty to make directions for not only the prosecution but also for the defence. Is there anything else that you need at this stage?
We do need to submit the application for legal aid completed by my client this morning.
Very well, then I'll order that that application is lodged within the next 48 hours and that you notify the court within 7 days as to whether that application has been refused. If so, whether or not your client is intending to instruct you on a private basis. You must also comply with the directions as to the service of any defence statement within 14 days of the service of initial disclosure. That is also the time limit within which you must notify the Crown of the details of any witnesses that you intend to call. Thank you to both advocates for greatly assisting the court with the management of this case. I think we can all now agree that rather than taking 1.5 days, that this case will fit into a morning of 3 hours.
Yes, sir.
Yes, sir.
So I'm aware there is a 3-hour slot available on the 18th of August at 10 o'clock. The defendant is on unconditional bail.
Mr. Newton, would you stand, please? Mr. Newton, thank you for your patience during the course of this hearing. I make no apology for the amount of time that I've spent in case managing this trial. You will note that some of the directions that I have made apply to you, and it's very important that you assist in the compliance of those directions. You must provide instructions to your solicitors. That means you must keep any appointments that they make with you. If you fail to provide your solicitor with instructions, then she is under an obligation to notify the court of that. Equally, you have a witness. It's important that you ensure that witness is readily available for the trial, and indeed that that witness attends your solicitors to provide a proof of evidence. In any event, you will not be given further time to discuss the issues in this case with your solicitor or advocate on the day of the trial. It must proceed on the date fixed. You remain on unconditional bail until 9:30 on the day of the trial. You must be here on that date. If you are not, then the trial could take place in your absence. The court will be asked to deal with the matter without you, and it most probably will. In addition, if you fail to surrender on that date, you commit a separate offence, and that is an imprisonable offence. So for both of those reasons, it's important that you are here. Thank you very much. Once you have the notice of adjournment, you're now free to go. Can I thank both of the advocates for their assistance? Would they please ensure the case management form is signed and that both sides have a copy before they leave the court?